So this week's topic is securities law and offerings. And I have to tell you, like many of the topics we've talked about so far, I mean, we could literally spend a week on this, right? We could spend a week on this and still not get to it. So this is a very broad topic and one that I've given you a lot of material in the slides themselves that I'm likely not to cover simply because there's too much to cover in an hour. And so what I'd like to do today is, and we'll cover all of the slides, but I'd like to give you an overview first of all, which I always like to do, as you know. Let's get perspective about what we're talking about. But what we really want to try to get to is what we do at RREAF, right? In other words, what kinds of securities offerings we do here at RREAF, and how we sort of run that practice and what it looks like a little bit. There's a bunch of nuance to it, as there always is in detail work. And so some of that we're not going to be spending any time on really on some of the nuances, but I'll give you an example of one that we're doing. In fact, I'll give you an example of what's going to happen, what's coming up in TC21, right? In the TC21 portfolio. And this would apply, I mean, when we get to that will generally apply to just about all of the multifamily portfolio sort of arrangements we do. And a lot of that's driven by the nature of the capital stack itself. And so that's one of the things you find out in this practice is that capital stack always comes together last. It's the last thing to come together in the deals. And it's the hardest part to make work, then adjust the models, and then from a securities perspective, properly disclose it to the people who will be the prospective investors. And so we're always kind of late to the party. The lawyers are always late to the party with the offering documents, trying to bring them fully up to disclosure because the capital stack has finally developed and we know who the pref provider is or the priority provider is, what those terms are, how that's going to impact the common or the Class A equity, and so on and so forth. And then the debt pieces and the like. So it's all a bit of a moving target and sometimes a bit of a jigsaw puzzle, trying to fit these pieces together. And our securities offerings are obviously a critical component in them. And what we do in them moves around depending upon what that capital stack ultimately looks like and then what the project objectives are. So let's talk about it, about these things generally. We're going to run through, you can see from, oops, I guess I'm supposed to do that. There you go. These are the topics we'll run through, and you'll have a page or two on every one of these particular topic items. We'll do a quick overview on federal security, on securities laws and regulatory schemes in general, both federal and state. We'll talk about what's state, and we'll have a page on federal securities laws or two, and then blue sky state securities laws. They're called blue sky laws. And then what is a security and what is an offering? The types of offering, both publics and privates, public offerings and registration, what they look like, and we won't spend much time on those. And those are incredibly detailed. There is a whole body of law and practice that there are securities lawyers that all they do are public offerings, that they tend to spend their entire career on nothing but public offerings. And it's a very detailed and difficult and regulatory driven area. It involves audited financial statements that are required, and then even formats for disclosures in the prospectus, what's called the offering document. It's called a prospectus. So all of that, I mean, we'll touch on that briefly, and then we'll get to private offerings, which is what we do here at RREAF. We don't do public offerings. We do private offerings, and specifically we do Reg D, what we refer to as Reg D private offerings, and we'll get into that a bit more as we get down to it, and then we'll conclude, okay? So let's talk quickly about securities laws and regulatory schemes in general. As I've mentioned earlier, there's a whole federal body of law, and then there's a state body of law that are called blue sky laws. So let's keep those two things separated from each other and understand that when we talk about registration or exemptions from registration, we're going to have to deal with those questions both at the federal level and at the state level. And that means at every state in which we offer. So if we do a large offering across our investor base, we may hit 40 states. And so if we were required to do a registration for our securities offering, we don't, but if we were required to do a registration, we'd have to do a federal registration, and then those would all have to be filed with the states in which we were, and we'd be subject to review at the state levels also, in the states in which the broker-dealers who would be doing the offering or we'd be selling into would be offering. We'd have to file with the Securities Commission in each one of the states in which we expected to offer. And the staff in each place has an opportunity to look at your materials, comment back on them and say, you haven't done a good enough job on this section or this section or this section, rewrite it. This is what we want you to do. Very much a back and forth process. That's what happens in public registrations. The lawyers for the SEC and the lawyers for the issuer will go back and forth a number of times with the offering documents to try to get the SEC happy with them, and they'll do the same thing with the state securities regulators. So where do the federal securities, let's start with federal, where do the federal securities laws really come from? Well, I mean, at the end of the day, the overarching notion was this. You remember the stock market crash of 29, right? You've all heard about it in school, probably, right? As a result of the rampant speculation that was going on during the 20s, the late 20s, in securities and trading on all kinds of things, and the crash of the market, because the failure of issuers to issue anything that was something other than, maybe in a hope, and with no basis for it at all in many cases. The laws were passed in 1933 and 1934, and then follow-up laws even all the way into the 40s that aimed at securities protections for consumers that required issuers, anybody that issues a security, has to either register that securities issuance with the Securities Exchange Commission in the states, or you have to find an exemption from registration, the registration requirement. And just because, again, you find an exemption under the Federal Act, under the 33 Act, the Securities Act of 1933, doesn't mean that you also have an exemption from the state blue sky requirements in every state in which you'll offer. So there are some times when you have an exemption under federal law and you do not have a qualifying state exemption, and you've got to go through the blue sky process, even though you have a federal exemption. It's unusual, but there are some situations where that happens. So what are our sources of law? The Securities Act of 1933. That's basically the act that says that if you're going to make a public offering, an offer to the public of a security, you have to register it with the Securities Exchange Commission and go through the registration process, unless there's an applicable exemption, right? So that's the general rule. Securities Exchange Act of 1934 was passed to say, look, you can't go trade a security later. The 33 Act applies to issuers, the original issuer that's going to act, the company that's actually issuing the stock or issuing the bond. That's the 33 Act. 34 Act applies to trading that security later, the movement of that security later, and what's required. Now, there's some crossover in it that as a matter of practice, we worry about. And you'll hear, in the securities practice, you'll hear people talk about, and you ought to be conversant with, what we refer to as 10b-5. 10b-5 is a reference to the Securities Act of 34, Exchange Act, Securities Exchange Act of 34's section 10b-5 that effectively says that an issuer of securities is required to disclose, make available, disclosure is a good word, disclose to any prospective buyer of that security all information that a reasonably prudent investor, considering an investment in that particular security, would consider material to making that investment. Well, that is a really, really broad standard, right? But it has to be a reasonably prudent investor we're talking about, so it's sort of what we call an objective standard. But it still means that we have to think through all of the things that a reasonably prudent person would say, you know what, that particular issue is important to this investment. I would want to know more about that. And you have to do a little, it's not guessing. You have to know enough about the business of the issuer and the markets they're in and the prospective risks that may occur or that investment would be exposed to over some period of time, not just now, but off into the future to let them know. So for example, could you have predicted COVID? No way. No way you could predict COVID. But guess what? Every one of our securities offerings since COVID has a COVID disclosure paragraph in it as a risk. Okay? It does. So these are evolving sort of processes as we go. It's not that really we're kind of learning, it's that we're continuing to disclose things that we know have been material in the past. So for example, if we did a construction project, and those of you that are in the construction department this summer know that the cost of wood, timber, building materials has gone up dramatically, and the delivery dates for those things are way, way, way out. Steel, the same thing happened with steel in building. Could we have predicted that as a consequence of COVID, right? That was just a consequence of COVID. And there was no way at the time when we did our offerings and raised money for the building projects we have going on right now that we reasonably could have predicted that. We did predict and we do disclose things like delays in contractors, delays in availability of materials, strikes, and other things like that. But could we have said, we could have this pandemic that occurs all across the world and shuts down production facilities in all the building materials that we're going to need. And by the way, we're not, all the projects are going to, basically go on halt. And the prices, by the way, are all going to double. I mean, that's the sort of stuff we're talking about. And so this is what we have to do in a securities disclosure document, is try to prospectively look forward and prognosticate a bit on what the possible bad things could be that will happen or that could happen in any case, even in the most remote cases, if we can reasonably estimate them. So that's one of the things we do. And that's required by 10b-5 of the Exchange Act. Investment Advisors Act, I'm sorry, that's a typo. That shouldn't say the Investment Issuer Act, that should say the Investment Company Act of 1940. Sorry about that typo. Should have caught that. That's the Investment Company Act of 1940. And then the Investment Advisors Act of 40 was a companion act that really deals with broker-dealers, registration, and the like. And when investment advisors, when and how, and they can advise what the limits of their advisements are, what requirements they have for disclosures that they may have that are completely separate from the Securities Act disclosures and the Securities Exchange Act disclosures that we make. The Investment Company Act is an interesting one that we get into a little bit because unless you have an exemption from it, if you create a company that invests in other companies, securities in other companies, you have to register that company, called an investment company, with the Securities Exchange Commission, and you have to report to them, and there's a whole bunch of consequences of it. And so we try to avoid the Investment Company Act, and one of the ways we do that is, like all of these laws, there are base requirements, and then there are exemptions from those requirements. And one of the key exemptions from the Investment Company Act is that we use in our structures is the limit of not more than 99 investors in the particular issuer's securities issuance. Not more than 99. 99 is the magic number. If you roll over to 100, you're subject to the Investment Company Act registration and reporting and everything else. So we try to maintain our compliance with the Investment Company Act by using that. And then another exemption in the Investment Company Act that you'll hear in our practice that is also particularly important, and we call it the QP exemption. It's a qualified purchaser, not to be confused with accredited investor, which we'll talk about later under Reg D. The Investment Company Act has what's called a qualified purchaser exemption, and that effectively applies to individuals or entities that have $5 million or more in investment, in investments. Those people are QPs, qualified purchasers, and as a result, under the Investment Company Act, we can create a separate entity, a separate offering entity that we call a QP sidecar. You'll hear us say that from time to time, QP sidecar, where we only issue out of that entity. It looks like the same securities offering we're doing over here with accredited investors, but we carry on two separate offerings at the same time, and we combine them for a total offering, but we keep them separated so that we have the QP exemption. And what that allows us to do is take in any qualified purchaser that comes in on the QP side is exempt from the count, the 99 investor count, all right? But we have to run two separate offerings at the same time to do it. It's part of compliance with the way the rules work, okay? So you'll hear us talk about that from time to time. Sarbanes-Oxley changed not only the securities area, but dramatically changed banking and bank reporting and all sorts of things. That was 2002. And then the Dodd-Frank, what you hear about as Dodd-Frank, people refer to as Dodd-Frank, effectively added a whole new layer of requirements to public reporting companies and their auditors, the lawyers that work for them, and their senior executive officers who now have personal liability for signing off on certifications and statements that are required for publicly traded securities companies that are reporting on a quarterly and annual basis. So I've now kind of flipped you through, and I'm sorry I left that up. I should have flipped through. We had several discussions. I mean, we've talked about, all through this list, but I've also talked you through, each one of these. You've got substantive sheets on, sort of quick highlights on the on each one of the major federal laws that I've talked about. So blue skies or state securities laws are again securities registration requirements at the state law level. There are a great many states that adopted or modeled after what's called the Uniform Securities Act of 1956. And there's a general exemption that we use in the private securities area called the ULOE, the Uniform Limited Offering Exemption, which if the state adopted basically from the Model Act, from the Uniform Securities Act, we see basically the same kinds of requirements under the ULOE exemptions that we try to get into under if Blue Sky applies to our particular offering. And we'll talk about when it would apply or what exemptions there are at the federal level, and we call that preemption. And I note that in this first bullet point that remember that whenever you have layers of law like federal laws and state laws that may conflict with each other or be involved in the same subject matter area, if it's something that under the U.S. Constitution, under the federal Constitution, the Supreme Court has decided is truly a federal matter, and it either as a matter of interpretation by the Supreme Court under the Constitution or by federal statute that's adopted by Congress, does what we call preempts state law, then the federal statute is what you have to comply with, and you don't have to worry about what the state says. If it touches the federal law or federal involvement, and the Supreme Court finds that it does have sufficient nexus with federal involvement that the law can stand and not be an imposition on state law rights, then the federal law will preempt contrary state law. Now, from a securities perspective, it's clear that the federal securities acts are not preemptive when it comes to the state's rights to also regulate securities offerings within their borders. The question is what happens when you have cross-border transactions, things happening outside of a particular state. Then what do the states get to do? Well, the moment you have an offering under a federal exemption scheme that offers into a state, to an investor in a state, the state right to regulate now attaches. Fortunately, there's a federal preemption scheme under Regulation D specifically, and we will talk about this in a little bit of detail. Yeah, we're going to have plenty of time to talk about it. This is what we really want to get to, is the Regulation D exemptions, and specifically the Reg D, what we refer to as 506. There are 2 sections of Reg D that are currently available. There used to be 3. I'll just tell you now, there used to be under Reg D 504, 505, and 506. And they did away with 505 when they made a modification, when the SEC made a modification to the rules as a result of realizing that it was an exemption. It was a $5 million maximum exemption that didn't make a whole lot of sense in light of the fact that we had 506B. At the time. And we will talk about the differences between 506B and 506C. But let me go back to my preemption comment here, and that's the real genesis of my beginning the comment on federal preemption. Regulation D, Rule 506C, Rule 506 is a preemptive statutorily, it is preemptive, and regulatorily, it is preemptive over state blue sky laws. There is the statute that modified the federal exemptions under the Securities Act, was modified to allow us to be free to offer federal or offer securities into all states in the United States without having to comply with state blue sky laws, so that we had a bit more freedom in capital raising, so long as we offered only under Rule 506. So virtually all of the private practice of private securities offerings these days, the vast, vast, vast majority of it is being done under Rule 506 exemptions, either 506B or 506C. And I can tell you here, we rarely anymore since 2016 do 506Bs. That was the old-fashioned way of doing things. There's still some call for it from time to time because of special nuances in transactions, but largely we operate under 506C, Charlie. I call that the Charlie exemption, and not the Bravo. And we'll talk about that in a few more minutes when we get toward a little later in the presentation. But that's what we're trying to work around. And by the way, there are a number of exemptions under the blue sky schemes, but every one of them is subject to its own state law requirement, because every state can draft its exemption scheme and its registration scheme separately. Right? It's not governed by federal requirements. State wants to adopt a particular set of laws, it can do that, subject to the federal Constitution, of course, and subject to federal preemption doctrine, which we've just now talked about. So let's get back to where we, this is Securities 101. In fact, your first class in law school in securities, you won't get the intro that I just gave you generally. Almost the very first question you'll get when you flip the textbook open, the case book open, and the professor stands up in front of you and says, all right, ladies and gentlemen, this is a class on securities. Who knows what a security is? Okay, I don't know. What's a security? So give me an example. Give me an example of a security. Come on, it's not that hard. Stock, good. Corporate stock. Stocks issued by corporations, not limited liability companies, right? Okay. What about limited partnership interests? What about limited liability company membership interests? What about a promissory note? Ooh, I've got one I know you all know, a bond, right? Bond offerings, traded bonds all over the place. What about options? What about swaps? Who knows what a swap is? Okay. Rate swaps. What about a rate swap? Security? I got a really good one. Bitcoin. What about cryptocurrencies? Are they securities? By the way, don't nod your head up and down and don't shake your head this way, because the question is still out there. We don't know. And the answer is, like every good question, at least to a lawyer, is it depends. So what does it depend on? Read down through this with me. By the way, you'll know this for sure. Anytime I highlight something, you probably ought to look at it. Okay? There's only two words that are highlighted in this entire definition. This definition comes out of the Securities Act, 1933. So there's this long list of all these possible things. Look at it, even an undivided interest in oil and gas. Right there in the statutory definition under the Securities Act. All kinds of things can be, quote, securities for purposes of the requirement to register that security, under the 33 Act. So I've highlighted the words investment contract, because back in 1946, a case came to the U.S. Supreme Court called SEC versus Howey Company. We call it the Howey case. And this was the first opportunity for the Supreme Court to interpret the 33 Act definition of what a security is, and it included the term investment contract. And by the way, cryptocurrencies will also be viewed under this exact standard. Why is this important? Obviously, it's easy. There's some things that are easy: stocks, bonds, and you can see the list: treasuries, treasury notes, security futures, swaps, bonds, debentures, evidences of indebtedness. By the way, evidences of indebtedness being promissory notes, so long as they're generally over about 9 months. If they're shorter than that, in most cases, they're not considered securities. Certificates of interest or participation in profit sharing, trust certificates, pre-organization certificates of subscription, transferable shares, options, calls, straddles, privileges, certificates of deposits, groups on indexes, all kinds of things, right? There's all kinds of specific things laid out there. But the Howey case focused on the two words investment contract. So let me tell you quickly about the Howey case. Howey Company, J.W. Howey Company, was in the business of buying citrus orchards in Florida and then selling off investment rights. That is, what they would do is it's a sale leaseback transaction. They would sell an undivided interest in the citrus grove, and they would lease it back from the buyer, who the buyer is the party that's buying the security, right? The contract right. They'd sell the undivided interest in the property, a sliver of it, to the party investing. They would then lease that property back. So they leased the whole property back, and then they would manage the property. They would grow the fruit. They would sell it. They would make profits from it, and then under the agreement, they would split the profits with the parties who they owed the rent money to, right? It was a lease back, right? So Howey Company said, that's not a security. Not a security. It's a real estate transaction. It's basically a secured real estate transaction. And the Howey court disagreed with that and said, that is an investment contract. Now, what constitutes an investment contract? Well, the bottom line in that test, the bottom line is that it requires a profit-making intention and obviously a transfer of money, funds, by the investor. But the real turning part of this test is that it requires not only an intention of making profit in a group, in a group setting, in a pooled setting. with intention to make a profit, but it also requires reliance by the investing party on a third party to manage that investment or process or enterprise, joint enterprise for them. So I think of that as a passive investor test. That's just sort of my gloss on the Howey test requirement to find an investment contract. So if you have those elements, we're going to have an investment contract under the Howey test. Some passive investor is putting money with you into a joint enterprise in which it's intended to make profits, and there will be a share of profits out of it if it's successful. Doesn't matter if it's successful, if the intention is to share profits. And that party that's putting the money in is looking to you or the issuer or a group of people, management or the like, for expertise and reliance in managing that joint enterprise. That's going to meet the Howey test. And now we have a security. And the moment you have that, all of the registration requirements, all the exemption requirements, everything just fall right into place. It's just like a share of stock. Just treat it the same way. Okay? That's where the significant issue is under securities law. First of all, we have to have a security, and then we have to have an offering. So we've looked at what a security is. Now let's look at what an offering is. And an offering is expansive in the definition of the Securities Act in Section 2. It's every attempt to offer or dispose of, or the solicitation of an offer to buy a security or interest in a security for value. So obviously we need to know what the definition of a security is to know whether we have an offer for the sale of a security. Obviously this is very broad also. Not only is the definition of a security expansive, the definition of offer is expansive as well. And so then we get on to the concept of public offering. And we really need to sort of work our way into that a bit. But let me just say that as a practical matter, anytime an issuer or an agent of an issuer is talking with a prospective investor party about a project or opportunity, even if the security is not ready for issuance, it could be considered part of an effort part of a public offering. So what's sort of the dividing line between public and private? Again, facts and circumstances test. It's not clear, but what we can say under the exemption scheme, specifically with respect to Regulation D, we know what the SEC, remember that's an SEC regulation. It is not a statute. It's regulatory. But it's the SEC's conservative interpretation of what principles need to be used so that issuers can have what's called a safe harbor. Regulation D is a safe harbor that says, okay, if you will follow the rules in Regulation D, we, the Securities Exchange Commission, will not claim that you have unlawfully violated the Securities Act, Section 5 of the Securities Act, by failing to register your offering. So it's one of the reasons that anytime you get a safe harbor of any kind, you want to look for it and use it, because if you just follow those rules, you're going to be safe inside of it. Now, does that mean that outside of those lines, it's not okay? Absolutely not. Section 4.2 of the Securities Act provides for not offerings other than to the public as a general exemption. Okay? It's called a 4.2 exemption. The Reg D rules have been written under 4.2 to give you a clear safe harbor. And so the question is, what's a public offering? What's offering to the public? And generally, the way the rules and the case law have developed is that if I'm talking to, and you'll hear us talk about this, Kip likes to use the phrase, but everybody does. When we talk about private offerings, we talk about friends and family. Offering to friends and family. If we offer to what we call friends and family, people that are close to our business, that we know personally, we have personal relationships with, that's not considered a public solicitation. I haven't gone out to the world and just said, hey, if you're an interested investor, please come. I've got an opportunity for you, right? That would be a public solicitation. So what's interesting about that, and we'll get to it in a little bit, what's interesting about that is what's happened as a result of the internet, the advent of the internet, its growth, and its use in offering opportunities for people to make investments. And so at the point at which it was growing rapidly in the 2000s and we got up into the early 2010s, Congress started to look at the issue of whether we really needed to adopt a broader rule that allowed for use of the internet without having every issuer, whoever put any statement on the internet, even on their website, as being involved in a public offering. Because they weren't talking only to people that they had relationships with, right? Personal relationships with. And so we end up with the Regulation D 506C. Remember I told you about Charlie, the Charlie exemption, which now allows us, in effect, to do what otherwise, under the standard definition of public offering, under the Securities Act, it would absolutely be a public offering. We're putting it out there. We're not only putting it out there, but we're sending mass email blasts out, right, to all kinds of people. And we're encouraging the market to come in and look at our website and potentially invest in our securities. It's being done all the time. Those offerings are being done under 506, Regulation D 506C, under the Charlie exemption. And we'll talk about that in a few minutes later because it really is relevant to what we do here. But so that's a public offering. That's what public offering looks like. And so if you're involved in a public offering and don't have an exemption from registration, what do you have? Well, we already kind of know what a public or a private, we've talked about public and private offerings generally, and you guys know what a public offering is, and you've probably even seen an S1 registration statement or an SK and the prospectus. I mean, it's 100 pages thick, and it's got auditor opinions at the end and all kinds of exhibits and all kinds of things. Certifications by the auditors, certifications by the executive officers, that sort of thing, required by Dodd-Frank and the like. So you kind of know what that is. And a private offering is everything but a public offering, and that would be something that we would then look at under Reg D. So public offerings, I'm going to skip through this. Public offerings obviously require a registration statement, and I just mentioned two of them. And by the way, there are also offering statements that can be done by foreign entities that are issuing foreign securities and can be registered here in the United States as well under a different under a different registration scheme. And we won't talk about those either. So let's go on to private offerings. Generally are limited in number of persons or to institutional type investors. Remember we talked earlier about qualified purchasers versus accredited investors. Talk about that a little bit more. Offerings of limited size. Intrastate offerings, and you all know what that means, right? That is an offer that only occurs inside the bounds of a single state. Now, I may not use a federal offering scheme, but I may have an exemption under the state blue sky law. I may still use a federal exemption even in an intrastate offering setting, but generally we'll try to look at, depending upon, the only time we look at these kinds of intrastate offering exemptions under blue sky laws is when it's really a simple deal. I just did one about 3 months ago for a client out of Houston that had 4 employees who were senior executive employees, senior officer type employees who were going to be, or senior management employees who were going to be investing in the company. And rather than go through the hassle of doing a Reg D and all that sort of thing, we simply did a limited offering exemption under the Texas statute. It was simple enough to do it. We filed a statement with the state. Some offering exemptions under blue sky laws don't even require a filing with the Securities Commission of the state, and some do, but don't involve review of the terms of the offering. So what kind of offerings would we have? As you see in your materials, we'll have Section 4A2. Remember I mentioned Section 4A of the Securities Act. We have what's called Regulation A, Regulation D. We've done a lot of talking about that today. Regulation crowdfunding, which you may have heard of, and I'll deal with that just very briefly. And then interstate offerings under this is Securities Act Section 3A11, and then Rule 147 and Rule 147A. Let's flip to the exemption scheme that we use, the Reg D exemption scheme. That's the one we kind of really want to focus on, that you'll know exactly how we do what we do, or not exactly, but why we use that and how it works. Reg D provides an exemptions from the requirement to register under the Securities Act of 1933, as we've discussed. It is a regulatory exemption scheme. It's not statutory, but it's based on statutory exemption, specifically the 4A2 exemption under the Securities Act. And that exemption also now includes additional language that was added to the statute in the 2012 Jobs Act, that then turned into regulatory changes in the addition of Regulation D, Rule 506C, that now allow us to do what we do, very broad, sweeping market exposure on the internet, and still not have that be considered a public offering for purposes of our Reg D 506C exemption. Those are limited solely to the Reg D 506C offering is limited solely to accredited investors. The Reg D 506B, I call it the old-fashioned Bravo exemption, that I started on at the beginning of my practice. That was all that was available at the time. Is one that allows unlimited number of accredited investors, but only limits you to 35 non-accredited investors. And so what's an accredited investor? Let's talk about that quickly. And I think I get to that. Yeah, it's right here at the bottom. And we can flip through the exemption scheme quickly. Rule 501 is the definitions. 502 is what's called general conditions, and you can read those for yourself. 503 requires issuers to file a Form D. So every time we do an offering here, we file a Form D. It's all electronic now. It has to be filed through their system, through the EDGAR system, SEC's EDGAR system. But then we file in the states as well. We file basically a Form D registration filing with each state in which we have securities buyers. In other words, a purchaser of that particular security we're offering. We register the offering, not register it. We file a Form D to notify the state securities board in that particular state that we're doing a private offering under Regulation D, Rule 506C, and here's how many investors are in the state. Here's how much was offered. Here's how much was acquired by investors in your state. And by the way, here's your filing fee. And under the federal preemption document, that's the sum total of what the states can require of us, other than there's one other technicality, and that is a service of process. We have to agree to be subject to service of process in that state, the issuer does. And that all happens electronically when we do these filings with the states. But in any event, that's the nature of 503. Rule 504, as I said, is a small issue exemption for under $5 million, and it exempts from registration these kinds of offerings. It has a different set of disclosure requirements, Rule 504 does, and so we generally don't use it, but in any event, there you are. Rule 506, B and C are both unlimited in size. Can raise as much money as we want. Remember, we're still subject to the Investment Company Act, not more than 99 investors in a particular offering. If the investment itself constitutes an investment company, that's important. We try to structure our deals in ways as many times as possible where we don't have an investment company that's issuing the Class A equity out to our investors, and as a result of that particular company not being considered under the definition an investment company, we're able to avoid the Investment Company Act limitation of 99 investors. We can take on more investors than that. There's ways to structure that, and some of that depends on the capital stack and the requirements of preferred or priority equity parties and the like. So some of that's a negotiation. Rule 506, again, B and C, unlimited in amount, but 506B, no public solicitation, and not more than 35 non-accredited investors, as many accredited investors as you want. And 506C, you can use the internet, so you can, almost like a public solicitation, but it has to be to only accredited investors, and there are more safe harbor rules in 506C that require the issuer to obtain a little bit higher levels of certainty that the people that are investing actually are accredited investors. So, and then 506 or 507 penalizes issuers who don't file Form D as required by 503, and Rule 508 provides guidelines on enforcement against issuers. There are also a lot of other requirements. Obviously, this is fairly detailed stuff. But let me go down through the accredited investor definition real quickly, because I want to show you something that got added recently by regulation not long ago. And that is, and you would just flip down through it, any officer, director, general partner, somebody who's an insider is already an accredited investor, no matter how much wealth they have or income they have. If they're an insider to the issuer, they would be considered an accredited investor. What we usually see in our offerings is investors who have net worth of over $1 million, of $1 million or more, but it can include their equity in their home. Okay, net worth test, $1 million, or in the income test, either $200,000 for the last 2 years plus a present expectation of $200,000 in net income during the present year, will qualify an individual as an accredited investor, or jointly with their spouse together, if they and their spouse together pass a $300,000 threshold for each of the last 2 years plus the current year in net income, then they will both be considered accredited investors, even if neither one of them passed the $200,000 on their own. Okay, so there's a sort of a spousal, and by the way, one of the things that changed in that definition was that you can see in the way it's written now. This comes right out of the new regulation. Section 2 there, or line 2, says, or joint net worth with that person's spouse or spousal equivalent. Regulation D was modified last fall to include spousal equivalents in the definition of accredited investor in several places, and you'll see it in some other places as well. Okay. And then banks, savings and loan. Remember, we talked about institutional type investors being qualified accrediteds. That's really that number 3, private development companies. And 5 is one that we typically use if an entity has in excess of $5 million in assets, not net worth, assets, then it will qualify as an accredited investor as an entity, so long as it's not being formed solely for the purpose of acquiring this particular security in this particular offering. Okay, you can't get around the exemption scheme or the requirements to become to register simply by having groups of people form entities together and then all invest together into one company to say, oh, well, that's just one investor, not all the investors together. You can't form companies purposely for the purpose of that particular investment and then claim that we, under the Investment Company Act, that we don't have an investor limitation issue. So that's important. And then some of the other things that got added are sections, and I'll leave you read them. Section 9, which relates to licensed broker-dealers, representatives. 10, knowledgeable employees other than officers and directors. 11, family offices as defined under the Investment Advisors Act. That hasn't been specifically, again, formed for purposes of that particular offering. And a family client. These are all new definitions that have just come in to the definition of accredited investor under Rule 50, under Reg D, rather. Back to 504 for a second. Let's flip through that quickly. Oh, going the wrong direction again. Rule 504 is a offer and sale of up to $10 million in securities in a 12-month rolling period. Issues required to file a Form D within 15 days. They also have to comply with the state blue sky laws. Unlike Reg D 506, Rule 506, 504s have to comply with the state securities laws, which is one of the reasons we don't use them. There's no federal preemption under Rule 504 offering. And there are some other requirements. The bad actor requirements are also required. They apply. Bad actor requirements or limitations also apply to Rule 506 offerings as well. All the Reg D offerings are subject to the bad actor, what we call the bad boy provisions. So for example, let me give you an example. If somebody is convicted of securities fraud, then and they want to go to work for a company that's going to do securities issuances and try to qualify under Reg D, that company will be prohibited from using Reg D because one of the bad boys has been convicted of securities fraud in the last 5 years. It's sort of a 5-year tail. You can't be bad boys and get to use the exemption. Just don't get to do that. All right. So Rule 506B, we talked about that briefly. 506B is a safe harbor under 42A, but it prohibits general solicitation. So under a 506B, we do not use the internet as a way to solicit. We contact our investors directly. And I can tell you, we've had a few of those offerings in the last few years where we've gone out to our specific investor group that's already in our system, that we already have investments with, that we already have a relationship with. We vetted, they're accredited, we know them, they know us. We're allowed to go out to all of them, even if it's 2,000 people. We can go out and contact all of those people under a specific offering under 506B, and it's not considered a public solicitation. Okay? So every once in a while, we'll use that where we need to. Otherwise, we never, ever take on a non-accredited investor in a Rule 506B. In my entire career, never taken on a non-accredited investor. You're entitled to up to 35, but the moment you take on one, you have to go back and restate all your offering materials in a format that's like Rule 504, which requires certified financial statements and particular presentation that makes it look like a registration statement. So when we call that, with respect to them, in the securities business, we call that offerings to widows and orphans, that 35 non-accredited investors. So we do not do that. Even though the law would allow it up to 35 under a 506B, we never do it. I've never had one offering. I've done a lot of offerings in the last 30 years. Never had one where we accepted an accredited investor under 506B for exactly that reason. Because there's tremendous accounting work that needs to be done, tremendous filing stuff that has to be done if you're going to bring a single accredited investor in. We've just found it's simply not economically feasible. So that's been my experience. And then 506C, which we've talked about quite a bit now, again, talked through quite a few times. We can basically use public solicitation using the internet, which is what we do very often in our offerings. Dari just put one out last night. I won't speak to which one it was, but we just put one out last night. And it goes out across the internet. It's available to anybody who comes and looks at our website. Then they have to go through a process to get in to see the materials. So we're vetting them through our online registration process so that not just anybody can come on, sort of filter through materials and we don't know who they are or have information on sort of their background or their qualifications as an accredited investor, because these offerings can only be made to or subscribed to by accredited investors. Right? And so we have an obligation as an issuer to comply with the law and make sure that we are only offering and selling to accredited investors if we can. let me finish, Daria, and then I'll take a question. So that's how we work our way through our securities offerings here at RREAF, largely under 506C, Charlie, and it preempts state law requirements other than as I said earlier, other than filing a Form D, with the state, with each state in which we have offerees, or subscribers actually, and then paying their registration fee, whatever that is. $300, $400, $500, sometimes as much as $1,000 or more for the registration fee in that particular state. The state, under the federal statute, the preemption provision, allows the states to do those two things, to require those two things under a 506 offering, either B or C. 506 offering, the states can do two things. They can require the filing of the Form D, and they can require the payment of a fee. A filing fee, but that's all they can require. Okay, that really kind of concludes my thoughts on securities very quickly. Sorry, it's a run through.